I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. I hate to say this, but I think the Third Circuit Court of Appeals, sitting in Philadelphia, made a boo-boo. In an opinion on February 1, it could be read to mean that the Third Circuit was not aware of the existence of Chapter 15 of the Bankruptcy Code. Here's what happened. A U.S. company sued a Singaporean company in federal district court. The directors of the Singaporean company consented to the entry of judgment against that corporation for almost $30 million. As it turned out, that Singaporean company was in bankruptcy in Singapore before the consent judgment was entered. Some good time later, the liquidator in Singapore learned about that judgment in the U.S. and came to that federal district court and, on the ground of comity alone, prevailed on the district court to vacate the judgment and to dismiss that lawsuit in federal district court. The case went to the Third Circuit Court of Appeals, and in the decision on February 1, the appeals court erected an elaborate set of common law rules allowing a foreign liquidator to come to the U.S. and enjoin or dismiss a lawsuit that is aimed at a company in bankruptcy abroad. Now, that's all fine and good, but it doesn't deal with Chapter 15, nor does it even mention Chapter 15. Professor Jay Westbrook from the University of Texas Law School in Austin said in the story that we published on the ABI website that the Third Circuit's decision is most unfortunate. And believe me, that is an understatement. In the ABI story, Professor Westbrook cites Section 1509 of Chapter 15, which says, in substance, and pretty clear as far as I'm concerned, that after the adoption of Chapter 15 in 2005, Chapter 15 was to be the exclusive method for foreign liquidators to stop lawsuits in the U.S. And so I think it should not have befallen the Third Circuit to set forth this elaborate set of rules that would accomplish the same purposes as Chapter 15. I would like to think that one of these days, sooner rather than later, we would have a split of circuits, and for the first time the U.S. Supreme Court could make a ruling on Chapter 15, but I think it's hardly unlikely that a similar case is going to arise anywhere else because, as I read the cases when they come down, judges everywhere pretty much seem to recognize that Chapter 15 is the remedy for foreign liquidators to accomplish what they accomplished in the Third Circuit. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. Good Lord willing, and the creek don't rise, I shall return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and a very good day.